Novato. With discrimination, I am transgender, male to female. I've been transitioning for the last 10 plus years. All of it has been spent homeless. And I've been discriminated against at Taco Bell across the street at 7th and not Grant Avenue, 7th and whatever that street is. I got into 2 fights over there. The cops came to one. The other one, I was outside smoking a cigarette. I went back inside. To go back inside the Taco Bell to finish my Coke and stuff. And a guy was coming out as I was coming in, and I grabbed the outer edge of the door that swings out with 2 of my fingers, and he pulled the door shut and pinched 2 of my fingers inside in between the 2 doors, the one that was locked and the one that swings open and closed. And I got into a fight with him. The cops didn't come to that one, but it was approximately 3 weeks ago, and the 2 fingers on my left hand still don't work right. So, I got chased out of the smoke shop. I got chased out of the donut shop. I got chased out of the women's bathroom at Lucky's. The Novato police continually harass me. And I was arrested on Grant Avenue a couple months ago for being under the influence of a controlled substance, when the truth is that I was asking for help because my 85-pound pit bull slammed me in the head with his head and almost knocked me out, and I had a concussion. And and I continue to get slammed in the head, and I'm still recovering from a concussion. And the police I sit down somewhere on a bench, mind my own business, be as law-abiding as I can possibly be, and drink a cup of coffee or drink a Coke or smoke a cigarette or whatever. And the cops just drive back. They drive back and forth and back and forth and back and forth. And then when the community officers can't find me on the street, then they come to the park and hi Leah, and it's just harassment. And I guess it's all because I'm homeless. I don't know, but it's not right at all.
Okay.
That's it.
Okay, well, excuse me. I appreciate that information, Leah. And I noticed on this draft complaint that you guys have put together, which, by the way, I have to compliment you. Whoever was the principal author of the complaint or whatever help you got has done a very, very good job. I'm looking at it. I don't know if everyone on the call has had an opportunity to see it, but it's basically a draft civil complaint, federal complaint, primarily focused on the threatened breakup of the encampment of Camp Compassion and some other related issues. And I notice, Leah, that you are a named plaintiff in the case. So you sound very in control of the ability to articulate what's happened to you, the discrimination you faced, the harassment by the police.
Well, I'm
glad of that.
I was the lead plaintiff in a class action lawsuit that involved 50 people that was in a mobile home park right here in Novato on Redwood Boulevard and Olive Avenue, where Trader Joe's is. Trader Joe's wasn't there at the time, but no one wanted to have their name as the lead plaintiff, so I was the lead plaintiff. So I know it from from the plaintiff end, but not from the attorney end. But I did, kind of work with the attorney, and it was Brayton Purcell. It was a contaminated well, and so I've had experience from the plaintiff end, and cooperating and working with the attorney as best I could. I did learn some things from him, though.
Yeah.
And that's a good segue for strategy. Like,
I was going to say, Leah, two things. One, before we kind of get into the meat of the complaint here, because I read the complaint, a draft complaint, took a lot of notes. It's an outstanding job, but there are things we should discuss going forward. And I need to get a better sense of what our time frame and what what we need to do. But I wanted to tell you, Leah, and others, that I actually worked earlier in my career. I actually worked with Brayton Purcell. So did you say that Brayton Purcell was your counsel? They were representing you in this?
Yeah, the attorney's name was Clayton Kent. That was before I started transition. That was in 1997 or 98. Clayton Kent was discussing it with another attorney, and I overheard the conversation, and the other attorney said, ask Clayton Kent, why are you doing this? And Clayton Kent's response was, because it's the right thing to do.
Yeah, good for him. Yeah. Okay. So I don't know if others want to make a little opening statement. I'm ready. I don't know how much time we have, but I have some questions, and then I wanted to kind of go through the draft complaint a little bit. But I'm going to defer to you, Jason.
Okay, great.
You're pretty much, I guess. I've been going around telling everyone that our Novato local is the newest local in the homeless union. So I hope I'm not wrong about that.
No, you're not, and I do have a couple things to mention.
Okay.
As far as the shelter is concerned, I've been calling every day for the last 2 weeks and documenting it, and they have no shelter beds. And I just heard the announcement today when I called that they are not taking any referrals until July 12th, which is 3 days after the ordinance is supposedly going to go into effect. So I don't see how, even with the ordinance disguised to get around Martin versus Boise, I don't see how they can even move us without any shelter space available in Marin County, let alone Novato.
Okay. I'll address that in a moment.
Sure.
And so you're saying, just so I can get an idea of the time frame, I understand that you called around to the shelters and ascertained there's no beds available. The earliest they'll be taking referrals will be July 9th. Did I get that right?
July 12th.
July 12th.
Yeah.
Okay.
July 9th they could evict us.
The 9th would be 3 days before, and that's when the ordinance goes into effect.
Yeah,
right?
Yeah, based on the CDC guidelines still, I guess.
Okay, all right. So it looks like what they're doing is anticipating that with the ordinance going into effect, they're already preparing a defense to any potential lawsuit by saying, well, wait a minute, we do have shelter space available. Referrals are now being taken. I've seen repeatedly representations made by defendants when the cities are defendants, and usually they're assisted, or in some cases assisted by shelter operators with declarations saying, oh no, we got plenty of room here, we don't turn anybody away, we got plenty of bed space. And now coming out of COVID, restrictions that may have applied on the number of people we can take have been lifted, so we have plenty of room. So that's always an issue, because that is that's going to be a defense when we raise the question of Martin versus Boise. Now I have things I can say about that, but at all times when you have litigation like this, you have to anticipate what your adversary is going to do and what they're going to argue, and sometimes you even put that in the body of your initial complaint, and you anticipate and already counter what you anticipate. In this case, the defendant's city of Novato would argue. And I guarantee you right now that they're lining up in order to have that defense available to them.
Oh, I know it.
Yeah. So I'm glad you, pardon me, I'm glad you actually called. You need to write a declaration in detail, which would include every call you made, to whom you spoke, when, at what time of day you called.
Oh, you've been doing.
Got
Yeah,
that.
you did
I already
that.
done it. I've already got it down
Yeah, we already did it.
for
Okay,
2 weeks
all right.
so far.
Yeah.
Okay, all right. And then, of course,
Documents on the
the same meticulous attention paid to the status of shelter bed availability has to be paid once the ordinance does go into effect, if we can't prevent it from going into effect. And quite frankly, I don't know how realistic it is to file this before it goes into effect. We could also file it after it goes into effect. It would have, there's no real, and in some cases it's even better, in some cases, to wait a little bit after some of these problematic ordinances go into effect. And then you can show both present harm and future harm if the court doesn't intervene. So
Okay.
we'll pass to that in a minute. I actually think what you've got here, it might be enough to halt the enforcement, to get a judge to enjoin the enforcement of the ordinance, but we'll see.
Okay.
But what I'm trying to say is that the question of shelters, and maybe you guys have discussed this, and you know a little bit about this, is not just a question of how many beds they have available. There are other issues involved in the question of alternative shelter, and they include constitutional questions. If you guys have you read Martin versus Boise, the actual decision?
Yes, I have.
Okay, Jason. Be good for everyone to take a look at it, or at least get a summary of it. But if you noticed in that decision, the court found that some of the shelters that the city of Boise had argued were available were not in fact available because, for example, they had a religious requirement. So
Right.
they may have been physically available, but they weren't constitutionally available because they had an impediment, and that was that they had compelled, under the First Amendment, they were compelling subscription to a particular religious viewpoint. And so because they had that, the judge said, well, that's not available. The same can be said for the Rehabilitation Act, which was the forerunner to the Americans with Disabilities Act, and now with the amended Americans with Disabilities Act. If you can show with evidence that that going into it, even before anyone goes into the shelter, that they lack the proper facilities, everything from on-ramps to storage facilities for personal mobile transportation devices, to privacy issues that might affect someone who has PTSD, you name it. People who have caretakers, support animals, you name it.
Well, I'm disabled. I've been a long time ago. I was by a psychiatrist, a licensed psychiatrist. I was diagnosed with schizophrenia and bipolar, and I do have PTSD from traumatic things that happened from childhood on. So, and I'm on Social Security disability insurance. So.
Right. And I also see by the complaint that you have physical disabilities as well. I don't know if you know, Jason, but a cancer survivor is by law is a person with a disability.
I did not know that.
Yeah, a lot of people don't. But I've gotten accommodations for people who have fully recovered from cancer, but the law categorizes them as currently disabled, even if they've completely the cancer's in remission or they're completely cancer-free. So that's something to bear in mind.
Okay.
But anyway, so what I'm trying to say here is that we should anticipate that they're going to immediately have available to them, that is the city, they're going to have immediately available to them this defense of, we have plenty of shelter beds available. A lot of these shelter operators will say that. They'll say things like, well, we don't turn anybody away. But I cannot emphasize enough that if you don't anticipate this, the judges tend to take the word of the shelter operators, they tend to take the word of the city for with making representations that we have shelter space in this place, that place. Now, we've litigated these cases where the courts have sat there and the city, we've had hearings. We had a hearing in Santa Cruz where they had city officials sitting on the witness stand testifying that they had 6 shelters available, and every one of them had been closed for weeks before we had the hearing. They just simply purging themselves on the witness stand. But we were prepared for it. And we were prepared with declarations and live witnesses who said, that's not true. I was in that shelter at this time and blah, blah, blah about that shelter. It's simply not true. I stood in line and I was only given, I was only put on a waiting list and I had to leave. A door was slammed in my face and blah, blah, blah. Or I was there for a night and I was evicted the next night and I said, there wouldn't give me a reason. So there's any number of factors that give us a basis to argue that in fact we do not have sufficient numbers of shelter beds. Now the other issue is we should make an effort to ascertain just how many people are homeless in Novato, because the way the law looks at it is, or ought to look at it, you can argue, is not any particular shelter has space, it's whether are there sufficient beds overall for the total number of homeless.
I can answer that for you.
Okay.
Okay, first of all, there's only 60 beds total in all of Marin County. 60 beds, that's it for all of Marin County, and there's 1,000 people homeless in Marin County. Maybe 700 currently, because I think they got 30% housed. But it's not even in Novato, it's in San Rafael. So I don't know if that'll affect anything. They're going to try to ship us out of where I'm registered to vote.
Yeah.
There's an elderly man here that's 73 years old that went to the shelter and he came back with bites all over him from bed bugs. And I experienced the same thing in the same shelter years before with bed bugs.
It's a new
So, yeah, it's not good.
But there's currently, I think, about 100 people homeless in Novato is what the officer said.
Oh, there's a HUD. We can use the HUD pit.
Okay.
It's 100, 200 or something.
The point in time
Okay,
has it at
so
300?
For this city.
300, wow.
Okay.
Okay, but I think we got to be prepared to argue it both ways.
Yeah, I agree.
Because the best is within the city.
And they don't get the dynamic of, it doesn't make any difference if on any given night you've got more beds than you've got homeless people showing up to take those beds. And we hear that all the time too.
Yeah, well, you know,
We had,
okay.
we opened our doors at 7 and we had, 20 beds and less than 3 homeless showed up. So hey, can't blame us. And they were half filled and they were half empty. We hear that all the time. And so then we argue, it doesn't make any difference what happened on any given night at any given shelter. You've got 1,000 homeless and you've only got, whatever, 50 shelter beds available. That's it. It's a per se
Right.
violation of Martin versus Boise, and you cannot therefore cite people for misdemeanor or other criminal violations of any kind of anti-camping ordinance. And I notice that your ordinance does provide for a misdemeanor charge.
Yes.
So you have to be prepared to argue it both ways.
Right.
The raw numbers, but also the actual each shelter, what the conditions are, how many times you called them, what you were told, personal visits to the shelters, declarations, and what I think that was. I'm not sure if that was who was making that comment just now. I guess Leah. I don't know if that was you.
Yeah, it was me.
Yeah, you're talking about the health issue. That if you have a declaration and perhaps other evidence, then that shelter is not available. And now I've
Right.
also heard judges, and most recently Judge England, up there in the Eastern District, talking about, well, what do they want, the Ritz-Carlton? I mean, they're just going to have to simply put up, it's better than being on the street. You got some of those hard-hearted judges up there. But I think an argument can be made if you have evidence and a signed sworn declaration that recently, it can't be like 5 years ago, but more recently, there was a bed bug infestation problem at the place. You were there, you saw it, you got bed bug bites, then that place is not available. It can't be just available because it's posted out of notice. It has to be available in actuality.
Sorry. One more thing. Also, the shelter beds are not immediate. It's not immediate shelter beds every day. You have to. There's only one day you could take a referral, or you could take. They take referrals, and that's Monday to 10 to 1. So each day you cannot call any day of the week and say, "I need a bed." They will say, "No, you have to come in on Monday to take a referral for intake."
Well, that's I would say that's a per se violation right there.
I'm telling you, it's the truth.
Yeah, if on Tuesday you seek shelter and you're turned away for that reason, obviously that shelter's not available to you.
That's exactly right. That's why I've been documenting every day.
Yeah.
And just one more thing. This is Leah DeAngelo again. You know, the thought of having to leave where we are, for me, it's a very, very scary thought, because, you know, I've been here for, I don't know, 5 or 6 years now, and you know, I have people around me that I trust and that I know will be there for me if I get into trouble, and it's a really scary thought to be totally and completely on my own and sort of floundering around like a fish out of water. You know, it's just it's a scary thought for me. So.
Well, you know, that's a very good point, and I want to kind of extrapolate a little bit beyond that point, because what Leah's raising here is the question of moving people from what we would call a relatively safe area into an area where they're put at an increased risk of harm. That's what state-created danger is all about. Is when there's state action, that means the action of the local government, a police officer, a ordinance or some enactment, which has the effect of moving people from one location to another. Affirmative state action. So it's important to show what we mean when we say the relative security.
And then the misdemeanor charge will, for a lot of people, they'll miss their court date, and then it'll turn into a warrant, and then the next time they go for, the cops pick them up on another misdemeanor charge, then they'll have a warrant, and then they'll go to jail for being illegally camped. Really?
Yeah, right. Well, we know that they just stack all this stuff up. But let's stay for a minute on this point, because what I'm trying to say is that the point you raised, Leah, about safety, community, access to services, access to Robbie's totally familiar with this. It's part of the argument successfully made in Sausalito. We were able to put in front of the judge, same thing in Santa Cruz, same thing in Sacramento, for that matter, of all of the services. We listed 15 different organizations, everything from a couple of junior high school students right up to the Veterans Administration itself over there in Sausalito, that were bringing regular survival services, COVID-related and otherwise. That's important to show this is a relatively safe place. Because then we can say, okay, but now you're threatening to move people to a location where they will not be as safe. You're moving them into a place where they would be at an increased risk that they would not be subject to had authorities just leave them where they are. Even if where they are is relatively not the safest place in the world. If they move them to a place, they move people to a place that's more dangerous, that's state-created danger. But the more evidence you put in there, it's an established community, that there's, food, there's volunteers that come up to help, that there's a sense of security. There's, our experience over the years is a lot of the women fleeing domestic violence come there. In your case, Leah, people that are otherwise marginalized and vilified, transgender, LGBTQ, whatever, they find a home in these encampments, and they're safer there physically and psychologically.
Yes.
So the more evidence you can put together to show that it's a relatively safe area, and that breaking up the encampment to the ordinance and without alternative indoor available in real time. Alternative indoor shelter, as Martin versus Boise requires. We're talking about state-created danger, and we're talking about an ordinance that can't be enforced. So that's good that you're. None of this has to be done necessarily immediately. I have to say, looking at the complaint, you've got the core facts there. I noted a few areas where it needs to be fleshed out a little bit more, just in terms of showing the basic elements. But California, well, we're in federal court here, but federal court is what they call a notice pleading jurisdiction. You only need to show a few facts. You don't need to spell out your whole case. You don't need to present all your evidence. But in my experience, bringing forward some of your most compelling evidence of telling a story, I usually lead my complaints with an introduction that shows some background, that shows how it is that people became homeless in the particular area, or I'll lead with a compelling story drawn from one of our declarations in Sacramento. Well, the Sacramento is in Marysville. In Marysville, man, we got this declaration from this woman who talked about she used to be middle class, and she had played in school, had nice clothes. She looked down on all the poor people, and then her husband lost his job, and found it very difficult to find employment. And slowly but surely, they sunk into a place where they were barely surviving. And so, where did they go? Where did they go to find to survive? They went to Hollywood. That was the name of the old mobile home park. It was one of the homeless encampments. It was cleared in 2016. And she said, and what I found there, I didn't expect to find. I found a community. I found people there who, like me, had fallen on hard times, and we took care of one. I can't even paraphrase it. It was such a beautiful comment. I led with the whole thing. I put pictures. I put photographs of our plaintiffs in the body of the complaint. In the body of the complaint, because you got to remember, I like to put a face on an egg. I like to say, okay, here's this plaintiff, Carrie Heelan. Here's Leah DeAngelo. Here's Donald Hobbs. Here's Jason Sarris. But here's what they look like. They're human beings. They look like regular people, that you see on the street, not knowing anything about them. And I also think it's important to kind of lead a complaint with a really, kind of grab the interest of the reader. You got to remember that most of these complaints are going to be read by a clerk. They're the ones who are going to read the complaint initially. And these, in federal court, they're getting hundreds of these things every day. And most of it's business. Most of it's one business entity suing the other one. You couldn't be more bored in your life if you had to sit down and read dozens of these bullshit civil lawsuits between company A and company B, man. So you need to grab the attention of the first officer of the court, whether it's a research attorney or clerk that's going to read that complaint. And you're going to grab the attention of the judge too. The judges are human beings, and they have to read all this stuff eventually. You want to grab their attention. And so you got to think along those lines. I'm not talking about some, Pulitzer Prize winning thing here, but I am talking about we have to distinguish ourselves out, and we have to kind of, like I say, immediately capture the attention of the reader. Because if you start, and I think we could kind of make this draft complaint a little bit more along those lines, and rather than push right into some of the more technical resolutions, 1669, but to kind of give the backdrop to what's out there. And then in comes these resolutions. They're going to cause all this harm to people we've just introduced you to. I know we have to identify the parties, and you did a good job there. That doesn't have to be extensive. But I think even in the introduction, which will give an overall context, you want to start the introduction of the plaintiffs, in a hard-hitting way, in a compelling way. So I'm kind of touching on a lot of different things, but what I was starting off by saying is we don't have to put everything in this initial complaint. We just need to put enough. But by the same token, it should be more than just bare bones. It should be more than just a straightforward cookie-cutter complaint. It has to be more more compelling and attention-grabbing. I think we should give thought to having some declarations, maybe one or two. We don't need them all. And photographs. Again, you want, one picture's worth 1,000 words. You can describe conditions, but when you actually attach a photograph of the present circumstances of what's out there on the street, if you can attach as an exhibit something summarizing the state of affairs in Novato, in Marin County, as it applies to people who are losing their housing, losing and becoming homeless. That kind of stuff is important. So you might want to give some thought to that. It doesn't have to be a lot. A little bit goes a long ways.
Okay. One more thing. Like the city manager, he's there. Novato's not giving us any option of where we can go. We've asked him. Nikki Silverstein from the Pacific Suns asked the city manager Adam McGill where we could sleep legally, and the city manager said wherever it isn't illegal would be legal. Excuse me.
Yeah.
And to me that's not giving us an option. We're not sure where we can sleep without being arrested.
And very good point. Very good point. That's there's no clear indication of you're not put on notice. You're not being sufficiently put on notice of where you can legally, in their view, be
24 hours a day, not just only sleeping.
The other thing that comes down, I want to stress that ultimately what we file has got to be as error-free as we can make it. As error-free as we can make it. Mm-hmm. I mean, that's going to have an impact on the court.
Okay.
The court shows that we mean business. The attention to detail has been put into the complaint. It gives the merits of the complaint more credibility. It gives the factual allegations more credibility. I can't emphasize enough. It's got to look good. It has to be free of error. You have to have subheadlines, subheads in it, so that the reading of it is easy. Sometimes they don't read the thing word for word. They scan it, and if you have subheadlines, and then within those subparts, they can kind of peruse it and see what's going on. Rapidly see what the claim is. Rapidly see what the overall facts is. And as I say, an introduction helps to set the tone too. That we don't assume they know things. Sometimes people used to say names or places or things, and you can't assume that the court knows anything about it. This is federal court.
Yeah.
Which they don't know nothing about Novato at all. They probably don't. And so we want to be the ones that have the most thorough knowledge of Novato. I'll tell you something else. They might bring in the city attorney. They might bring in outside counsel. Outside counsel usually doesn't know any. They don't know as much about the actual condition as we do, because we're on the ground. We've been there forever. Our people, most of them, 75%, born, raised, spent most of their lives in the city where they became homeless. But the federal judge, is almost certainly not going to know a whole lot about Novato. So you can't assume when you write this that they do. You got to kind of make a claim. You got to kind of spell some things out. You want to paint a clear picture. The court will appreciate that. It looks like you guys follow to some extent the elements of the ruling in the Santa Cruz case, Judge Van Kulen's ruling, and right?
Yeah.
And maybe some of the stuff that we filed. That's good. I tell you, there's nothing wrong with Judge Van Kulen's original ruling. Was an excellent ruling. And Judge Chen's ruling in Sausalito, that's a good ruling too. We also had a ruling in Sacramento, but I wouldn't use that because, for one thing, it was in state court, and also the judge was very hostile. And the only reason she gave us our writ of mandate was that 4 days before we filed, we were able to get the public health officer to essentially issue an order to stop clearing encampments. Okay. And that's what really moved the court. Once the court saw that there was an already existing order, and we came in with evidence 48 hours later that the police were violating it, wham bam, we got our writ of mandate. A writ of mandate is a command by a court to an agency or sometimes to a lower court to do what they're already required to do. But our original lawsuit, we argued different elements, and we had a different legal basis. But once we got that that public health order, we were good to go, and we got our writ of mandate. But in 2 federal cases, I think the original decisions in both cases are very good, and we can cite some of the citations. And also it helps the judges know that other northern district judges in the Northern District have looked at this issue similarly. The biggest challenge we have, I think the biggest challenge we face, is that we filed our lawsuits within the context of COVID.
Mm-hmm.
We did that deliberately because just to take on the whole issue of homelessness, to take on the whole issue of the mistreatment of the homeless and all that stuff, you're not going to get injunctive relief without some detailed preparation, and it's going to be very difficult to get injunctive relief kind of along those lines. So we had an opening. The COVID-19 was the weak link in the chain. The fact that the cities and counties weren't doing anything, our local unions were able to move in with Project Survival, especially in Sacramento, Santa Cruz, Salinas, and then and then right alongside that, following the lawsuits, and we based it on COVID, violating CDC guidelines, and wham bam, there's shelter-in-place order, wham bam, and Judge Kuehlen and Beck Kuehlen was able to say, well, as far as she's concerned, shelter-in-place meant stay in that tent, and it meant don't tear down that tent, city of Santa Cruz. But we can't. We're moving away from that, and I noticed that in this lawsuit, we are moving. In the draft, we are moving more to some of the more chronic pandemics that we face all the time. And what will happen with the specific breakup of this camp. And I think that's a good thing. We had hoped that we could kind of transition in Santa Cruz because the judge had indicated some broader concerns, but she made it clear that she was not going to entertain any direct challenge to. They've got an ordinance there that they just passed.
Right, I heard.
Yeah, they haven't started enforcing it, but she made it clear that she wasn't going to move her injunction too much past, or it really past COVID at all. And she's sticking to her guns on that. And I understand that, because to get an injunction is a very, it's what they call a disfavored remedy. They're not issued. You can't just walk in and get one. It's a high standard. It's a little bit easier in the Ninth Circuit than other circuits because we've got that Cottrell case and the sliding scale. They don't have that in most circuits, but we have it here in the Ninth Circuit, and that's a good thing for us. But I like that you guys are moving it into. You've got some aspects of COVID in there because COVID is still with us,
right?
And CDC guidelines are still there.
Yes.
And we should definitely emphasize that. But I see that you're transitioning, and I think that's a good thing. I think it needs to be.
Me too.
I see your claims. You've got the 1983, of course, that's the Civil Rights Act. And we have the 14th Amendment due process, substantive due process, state-created danger. That's all good. And in the previous section, you've got good facts to show that. You've got the California Constitution. That's also good. And you might also want to put in some other provisions of the California Constitution, because unlike some of the, I guess it's the Declaration of Independence that talks about federal, Thomas Jefferson talked about life, liberty, the pursuit of happiness. The California Constitution actually talks about the pursuit. The Californians have the right to pursue and obtain life, liberty, and happiness. Did you know that?
I did not know that.
Yeah, most people don't. But I've raised it to say that, you can't achieve happiness if you're homeless. You can't, if you're being chased from one part of town to the other, if you're being denied the basic necessities of life, and under threat of criminal prosecution. So this is a violation of that particular article of the California, and I'll provide that to you guys. But here, it's even stronger, because not only do you have the right to pursue it, you have the right to obtain it. And I think it's time to start putting some of this language in. It can't be the main focus because this is a lawsuit. This isn't just a treatise we're writing or a complaint or a manifesto. You know what I'm saying? But having said that, I think it is time to start raising some of the issues that have not been raised for quite some time, and a lot of lawyers are hesitant to do it because they think they'll be laughed out of court, or they don't think it's practical. Well,
It's valid.
It's time to start making this an issue. It's time to start raising the questions of the fundamental rights of human beings. And so, but we have to do it in such a way is that we got one foot in the traditional law, solidly, and then the other foot pushing that out. You guys know what I'm talking about?
Yeah. Hey, Anthony, did you see the City of Chico federal injunction? The homeless just got on Chico.
Yeah, I saw the judge's order. I know they're going to be back in court on July 2nd as to whether he's going to lift the injunction, or I should say the TRO. There's no injunction, but he ordered a TRO.
It was very compelling. I thought it was well done. Or how they ruled it was pretty neat.
You talking about the order itself, or the argument, the hearing?
Yeah, what the court said afterwards. The
Final judgment.
The final judgment on it, or whatever.
Well, I don't know that there has been a final judgment.
Oh, okay. Yeah, their argument. Well, they tipped it. They said it tipped towards the homeless on every count that they did. I guess. I'll have to send it to. I'll have Robbie send it to you right away. But it was like.
Yeah.
The Chico Mayor.
Yeah, and it was very. It was tilted in our direction, and it was. They raised some concerns about Martin. It was a lot about Martin versus Boise.
Yeah, I think we're talking about the same thing.
Yeah.
Yeah, that was. I saw both the transcript of the hearing, and I also saw the order. And Judge England was pissed off. He was pissed off at both the city, and he was somewhat pissed off at the plaintiffs too. I think he was the one that made the comment about what are these, it's a shelter. What you guys are saying no. Okay, the hell with you then.
Oh, okay. I didn't see that part.
Playing on both your houses.
Yeah. Okay.
I was actually in front of Judge England years and years ago. He is a very conservative judge. He's no friend of the homeless, but I think he got pissed off because the city was supposed to send him a report and they didn't, and he got mad at him. And I think I actually think he wants to get rid of this case. He's going to make those parties work something out. That place that the city wanted to move people was ridiculous.
It was.
We wrote we wrote a cease and desist letter on it that got the mayor all pissed off.
Oh, okay, that was you? Nice.
That was yeah. He claimed never to have heard of the California Homeless Union, which is ridiculous because after the Paradise Fire, we were all over up in Chico because Chico was not doing nothing for what the city of Chico was doing was trying to divide the homeless that were made homeless because of the fire and those who had been homeless for a long period of time.
I see.
Yeah, at the Red Cross shelter, they actually let the Paradise refugees sleep inside, but they made the homeless who had been down on the streets in Chico for years, they made them, you guys stay outside. And right at the same Red Cross at the fairgrounds.
Oh my gosh.
Yeah, we had a protest out there. So that goddamn mayor, he can't say he never heard of us. We were right out there in t-shirts.
Yeah.
Anyway, he got pissed off at us, but the point of it is that public opinion, even Butte County has now taken a position. We don't support moving this encampment over to the space by the airport that they want to move it to. I mean, it's just a terrible location. These locations they're talking about moving human beings to. I mean, this is all part of that process of dehumanizing people to the point where society just doesn't care whether they live or die. That's what's going on here.
Yeah, I see it.
Yeah.
I feel it.
That's exactly how Marin County feels. They don't give a shit whether they live or die.
That's it. And sometimes
many people have died on the streets. Many.
Yeah.
Many of them were my friends.
I'll tell you another story about Judge England. I'll tell it to you real quick. Years ago, when I first practiced law, I worked for a little firm, and we got a case that no one else would take. And the statute, the time for discovery, which is where both sides exchange information, and take depositions. That had passed, so I had to file a motion with Judge England to reopen discovery, and he so he said, well, Mr. Prince, I said, well, we don't, why didn't you pursue discovery before? Well, within the time limits that the federal rules provide. I said, well, Your Honor, it wasn't our case then. This case came to us from another law firm that really didn't aggressively pursue the case, and they didn't serve discovery, and so we now have the case because we're trying to do right by this guy, and he was wrongfully discharged from his job, so the judge said, well, do you want some special treatment here, Mr. Prince? Do you want a different standard? Do you want the law to have a different standard for a little firm like yours? You're saying, yeah, I get it. You're saying you don't have the resources, and so you weren't able to do it now, and you're asking me to reopen discovery, all because you just got the case and you're small. I said, well, actually, Your Honor, that's exactly what I'm asking, because you guys, every year you put out a statement, the Judicial Council puts out a statement complaining about the fact that 86% of Californians don't have the way to even get into court, that not enough lawyers are taking cases, that there's no pro bono work going on. I said, the whole firm I work for, Your Honor, is practically a pro bono firm. We take a bath on every case we take. We don't make any money on these cases. We take the cases no one else will take. I'm not asking you for a lower standard, Your Honor. I'm asking you to level the playing field.
Nice.
And he reopened discovery for me.
That's a great answer.
There you go.
Yeah,
That right
that's
answer.
true. And I'll say it again. When it applies, it's really true. You're up against these guys with all these resources and all this ability. I mean, that's really why we lost the thing in Sausalito, was we just couldn't compete with the expert witness that they brought in. You know what I mean? We couldn't bring in the expert witness I wish we could have brought in. We just didn't have the money, didn't have the resources. It's a challenge. You can't use that as an excuse. We're going to have to figure out ways to finance this litigation. That's another discussion. But, we have to accept the reality that we are under attack, and that we have to do the best we can, but anticipate that we're going to be on the defensive, and we're going to be up against people with superior resources for quite some time. That means we've got to think smart. We've got to find the weak link. We can't just file lawsuits. We've got to build this union movement. You know what I'm trying to say?
Yeah,
and that's
exactly.
our attitude. I was an organizer long before I became a lawyer. And for me, just being a lawyer, that's just more weapons in my arsenal.
Gotcha.
About organizing. It's still about organizing. If you want a favorable ruling from the court, you've got to have enough in there so they're persuaded to issue a temporary restraining order. Because it's the same standard. You have to show that the harm that's threatened is irreparable. You have to show the balance of interest favors the homeless at Camp Compassion. You have to show, that it's in the public interest. You have to make all these showings. And by the way, that's something I didn't touch on, but you guys are going to have declarations and statements in here. You've got some of what will happen if this law goes into effect. And it has to be as specific as possible, and it'd be best to have a couple of declarations from your named plaintiffs of what specifically will happen to them. Like Leah, just to take you for an example, if the camp is broken up and you're exiled into the streets because there's no shelter, or even if you get into a shelter where you may face almost certainly discrimination based on your orientation or based on the fact you're homeless, your history of being constantly harassed by police and even local businesses. That shows that harm could be irreparable. Now, irreparable harm also is a constitutional harm, and you have a right under the 14th Amendment and the First Amendment to bodily integrity. And so if we say that there's physical harm that will come to you guys, if you're out there and you're in the elements, or you're camping by yourself, or you're at further risk of exposure to the heat, you have to walk around town carrying everything with you, even carrying 2 jugs of water to survive in the heat is impossible for a lot of people. You know what I'm saying? And especially for those with disabilities. So I think we'll be okay on
especially for me, because I'm 5'2", I'm 62 years old, and I weigh less than 100 pounds.
Yeah. Okay. All right. Well, I think we'll be okay with that. So the issue is the question of let's just get this thing done and get it filed, and I'm happy to file it and be attorney of record. You guys could also proceed pro se, and then later bring me on as an attorney of record. But I'm happy to put my name on it, so long as, and I want to make this very clear. I mean, I already have told the other officers in the union. These cases take a lot of time. They take a great deal of work.
Exhausting.
They're not easy. They're time consuming. They will file there will be a hearing. They'll file a motion to deny or to dissolve the temporary restraining order. We'll have to file motions against that or reply to that. It is a huge amount of work. So I'm going to tell you that if you guys are able to do this caliber of writing, this is good writing here. If you're willing to do this work, get these declarations, actually draft some of these legal documents. I'm happy to edit them and work on them. If you'll do a lot of the work, then I'll come in as attorney of record and we can file this on behalf of the union. Because I think that filing on behalf of the union is actually the best way to go.
Okay. I think the attack I want to try to make is the fact that, with the city manager, the city of Novato not telling us where we can sleep legally, that's going to put us in duress right away.
Yeah.
And the fact that there's no shelter beds and that we could prove that, I've been proving it. I think that they're not giving us any option other than leaving town or be arrested.
And also, we do have to address at the outset Martin versus Boise.
Yes.
We have to tell the court that the city of Novato has joined the ranks of other cities who are misapplying Martin versus Boise, twisting the holding, and attempting to have the exception swallow the rule. That's what they're doing.
Yes.
We need in this lawsuit to have the true purpose and underlying holding of Martin versus Boise obeyed. Okay?
I agree all the way.
But they're already kind of defining what they mean by infrastructure. This definition of infrastructure is ridiculous.
Oh, I can't believe it.
Yeah, that's ridiculous. And then how with the question of have an adverse impact on it. What the hell does that mean? I mean, they've essentially eliminated every single place a homeless person can go.
They did.
That exception completely swallowed the rule, and we got to challenge the fact that we have to say, Your Honor, you can't let this happen.
Well,
There has to be a specific. There has to be a showing, affirmative showing made by the city. We should be the ones that have to make that showing. They should make the showing as to why they can't make repairs without moving the homeless, or if they have to make necessary repairs, or they have to particularize what they mean by having moving encampment that might be near a freeway or whatever. How is that actually imminently threatening the infrastructure or some other public function? See, they're not doing that. They pulled that bullshit in Sacramento, and they kicked people off the levee because they said they needed to make repairs to the levee. And they kicked everyone off. They put up a sign with shelters they could go to. Every one of the shelters was closed, and they used the infrastructure exception to the public health order. And then of course they made no repairs to the levees. Not one single repair. It was just a trick. The Sacramento State Court judge fell for it too. We brought a motion to show cause why they shouldn't be held in contempt. And she went right along with them that, that's infrastructure, that's critical infrastructure. I'll leave it to the city to decide what that means. They're the ones in the best position to determine that. And I said, well, what about the fact that they have no place for these homeless people to go?
Right.
I said, they still have that obligation, whether it's legitimate repairs or not.
Right.
She didn't agree. She said, I don't think there's any obligation to provide alternative housing if you're removing people from critical infrastructure. I said, well, Judge, why? Why do you, we had a real contentious hearing on that one.
Oh, I bet.
All right.
You guys are doing a good job.
Appreciate
it. You never know what's going to happen here. We're in a hostile environment, and our perspective on litigation is to use it to build our movement, to use it to build a union, that win, lose, or draw, we always win.
All right, sounds good.
Can I ask a quick question?
Yeah.
All right.
Yeah.
Did you guys decide to do it before or after July 9th?
I think we should press to try to do it before.
Me too.
To stop
Yeah.
this?
Let's do
Yeah.
that.
Yeah.
Let's plan maybe. Let's get this thing done. Get it done right. File it before it goes into effect. Even if we file it 48 hours before it comes into effect. And if we can't, simply because of logistical things that come up, because they do, we'll file as soon as possible afterwards. But I'll tell you one thing we'll do. We will definitely send, before we file it, a cease and desist letter, a notice. So you can tell the judge, we notified the city. We wrote a detailed letter spelling out our concerns as to what they were doing, why they were violating the law, putting people at risk, and they refused to suspend enforcement. So we'll get the thing done as quickly, but as in a quality job as we can.
Thank you.
Okay. Thank you.
Thank
Okay.
you.
Thank you very,
All right.
very much.
How you feel?
You know, he definitely, he definitely voiced his concerns, so that makes me a little concerned. But I feel that the best way to attack him is the fact that they're not giving us an option and that there's no shelter space. Fact.
Even 60 out of 100, unless it evens out or there's more availability than people,
Yeah.
then you.
Well, it's
that's
never going to be like that in Marin because there's only 60 beds for all of Marin.
There's only
Yeah.
one shelter.
That's horrible.
It's one shelter.
There's Mill Street in Centerville and New
Mill Street's not
Beginnings.
Mill
That's
Street
all
anymore.
there is.
Mill Street shut down. They tore it down. So it's,
Oh,
at
Kerner.
it's Kerner Street now.
Or yeah, Kerner and Mill Street. That's all there is.
There's no Mill Street.
I
So
mean,
just
Kerner and New Beginnings.
Yeah, New Beginnings. And that's
New
transitional
Beginnings.
housing. That's not shelter. You can't just get into Homeward Bound. You have to go through,
Coordinated entry.
you have to go through coordinated entry.
It's not even an option.
They don't even have enough caseworkers to handle that.
Yeah.
I guess Robbie or Jason, can you just summarize the phone call without giving any specifics away? What's the plan?
I like the fact that we're going to try to go through go with Martin versus Boise, and try to get that involved with this injunction because it's the very essence of what we're getting criminalized for, and I believe that is the best route for us to go. Yeah, I think the fact that they're not giving us a option, the city manager can't even say where we can legally stay without getting arrested or criminal ticketed. I think the date I think that's just horrible. I mean that's going to put, I can't imagine, after being here a year, I can't imagine not knowing where to sleep where I could possibly be arrested, and the fact that there's no plan. They have no plan. They just want us out of the park and that's it. And that's that kind of attack I'd like to go with. What do you think, Robbie?
Yeah, I like.
Clip the
I think
mic.
the fundamentals are coming out. And I think.
I think their ordinance is going to definitely showcase the fact that they're just saying, we don't care about Martin versus Boise. Bring it.
Yeah, and further demonstrate how, I mean, the real crimes against humanity, like the dispossession of so many people in our community.
I think when a federal judge looks at that ordinance, I think they're going to be all, what the hell is this? I mean, what the heck? I mean, what are you guys giving these people? You're giving them nothing except the possibility of being criminalized. I think Lucy Hollingsworth said it best. She said that you're either going to criminalize people or you're going to make them leave town. And that's pretty much what it's come to.
Yeah, I agree. I mean, let's.
So the plan is to fight?
The plan is to fight.
Yeah, the
I
plan
think
is-
we should. We gotta send Prince all those emails I sent you with all the every
Yeah.
day that I.
Yeah,
Do you
yeah.
have those yet?
Yeah, I have. It's just I didn't add them into the declaration.
Add them into the declaration
Yeah.
because I mean today I just posted the fact that there's not going to be any. They're not taking referrals at Kerner Street. They're full. They're not taking any referrals till July 12th, and that's 3 days after the the ordinance is supposed to kick in. So you can't even get immediate shelter any day at Kerner Street. And the fact that they're not taking any referrals for intake, and that referral for intake's not immediate, and I think that's what they need is immediate to arrest us on.
So break it down for me as if I were a child. I understand what you're saying, that
Right.
there's no beds available and no intake till 3 days after you're already kicked out,
Right.
which means they're kicking you out when there's no available shelter space.
Yes.
I guess explain that to me.
Well, I think the fact that, you know, for them to criminalize homelessness, there has to be a alternative shelter.
Reasonable alternatives?
Yeah, reasonable. Yeah, it's a reasonable alternative for an indoor shelter that's easily accessible. And you know, without being able to get to a shelter that's easily accessible, without doing a referral, without getting an intake, I don't think that they could. I don't think they could legally do this. It's my opinion.
So what do you think they're going to do to get around that?
They're gonna, you see, they're trying to say you can still camp somewhere at this park. It's got to be 50 feet away from the creek, 50 feet away from the library right here. And so they're trying to say now, oh, we're not criminalizing homelessness because people could still sleep here or camp here. You just have to break down your camp every day. And
Store it where?
And store, we don't have anywhere to store it. They say we can't even store it within 50 feet of an infrastructure. So even if we do have spots we could camp here during the day, you know, they're not going to get us out of the park. Even if we can camp here during the night and during the day, what are we going to do? We're going to break it down. We're going to hang out with our stuff so it doesn't get ripped off, and we're going to still be at the park. So they're really not. They're not accomplishing anything. And what do you think, Robbie?
Anyway, I think the cruelty is being seen, and I think that's what we're going to highlight. And I think that, but I think even besides the lawsuit, at the end of the day, it hits something, but then, you know, we're seeing how it went in Sausalito, how it kind of, we pull out the threads where we can get them, but ultimately the strength in it is in our unity, it's in our ability to stand up to them and to show the world what's actually going on, and peeling back the curtain of untruth that all these service providers and all of the different law enforcement, city managers, everything that they're doing to continue the oppression and disposition of large segments of our community, so that others, people of privilege, can enrich themselves and maintain the status quo, and that all the overtures of compassion that they're offering are pretty empty.
Very empty.
And that's the beauty about the court, is that once even just a small level of scrutiny demonstrates how remiss our society is in this whole situation.
Where do you think the hate comes from?
And it's like a mythology concocted for rich people's benefits. So they, you know, we have an economy that's like musical chairs, where there's always less and less, and every time people go around, one more person gets popped off in the streets. And in order for the people that still have the chairs, well, those chairs keep on getting better and better too. It's not like good-looking gilded chairs. They have to mythologize all the people that got kicked out and say, oh, that's why. It's not because I'm benefiting from an unjust system. It's because of their dirty, undeserving, and dangerous, and all that. Apply that mythology to benefit themselves. It's a stigma. It's all working out for somebody, but not us.
So if Novato were to do something like Sausalito did, where they designated an area without any input from the homeless, would that be acceptable if it were close?
They gotta communicate. They gotta communicate. 'Cause, I mean, you could talk about that, man.
I would say that it has to be something that it can't be like out in the sun. It can't be like it can't be, policed. I would have to look into it closely. I would have to it would have to meet our criteria. And our criteria means that, it has to be something that's close to a store, that's easy accessible. There's got to be shade. There's got to be, with the summer coming up, it's got to be something that is not going to be like a intermittent camp. It's got to benefit us more than it's got to benefit them. Yeah.
Not an internment camp.
Yeah, not an internment camp. Yeah, because it's such.
What did I say, intermittent?
Close.
Which is basically the same word,
Yeah, there you go. Yeah.
just different stigma.
Yeah.
People are gonna know.
So how are you feeling after this call?
I feel good. I'm glad that we have an attorney on record, and I think his heart's in the right place. And I think that we just continue to do the legwork. I think we're gonna I just want to get something in court. I just want to get it in there. I want to back up the city of Novato a little bit and say, whoa, dude, you guys need to back off. You need to just give us some options without criminalizing us. And I think that's what it comes down to. That affects me the most, because between 2014 and 2018, before Martin versus came into effect, they had it was illegal. It was a crime to sleep in public with misdemeanors, and I was woken up out of my sleep and arrested, and brought to jail, and
Were you charged with anything?
I was on diversion at the time, and what they do is they'd terminate my diversion, they would reinstate it, and then they'd add the place that I couldn't be at. And so I had a lot of places I couldn't be at, and I'm like, I'm not a threat to this area. It's not like I'm going to attack it, So the stayaways were bad, and now with this new ordinance, the stayaways are everywhere. Everything is considered critical infrastructure, and so that to me is the meat of it. I can't handle the fact that I'm going to be terrorized about when you have to find a new place to camp, you have to get adjusted to the area, you have to get adjusted to the sounds, to the lights that are coming by, and it takes you a couple weeks to even settle down, and then next thing you know, they're all, you got to go, and then you spend a week not getting much sleep, trying to find another suitable location. Do I make it fancy? Do I just try to sleep and not worry about it, and try to just stay low, or do I own it and make it like I want it to be, to where I feel safe? Because I mean, any this is primal. Any animal being in this planet builds themselves a home. They have a cove, they have a cave. You sleep next to a tree because you want your head protected. That's the kind of things that you want to nest. I mean, it's primal to nest and to feel safe. And to me, that is what's going to be taken away with this new ordinance.
Different subject, real quick. How influential do you think these MMR, anti-homeless group is? Like, how instrumental or effective do you think they're being?
I think they are small and loud, and I think they're starting to crumble.
Say it as a sentence. I think who is small and loud?
I think Moving Marin Ride, MMR, are a small group that half of them don't even live in this town. I think they're a small group that is very loud. They're the Marin GOP. They're the far right wing fanatics. And I think that the more that we put pressure on the city like we've been doing publicly, I think that the louder they're trying to be, but I think it's starting to fall on deaf ears.
I gotta dip back.
Thanks, man.
Yeah.
Let's get them. Let's get them. So you're gonna get. So you're gonna get the complaint, and I think we're gonna do hell more of that pro se stuff.